or whatever the case may be, and we may be subject to, under those circumstances, if nothing is done and contact is, even though people have made reports, informal, informal, to be determined, and something does happen, we don't know. What is the liability of this body? What is our responsibility to do nothing?
Thank you, Mr. Chair, Senator Manning. That is exactly the concern I had in reaching out to the branch and issuing this memorandum. The worst position for the branch, knowing in light of these statements and following them and knowing that employees had expressed concern, is to do nothing. On the risk, of course, which is everyone's hope that this is not the case, but it does happen in some employment settings. And there are a couple reported cases in Oregon. If the branch does nothing and knows or has reason to know about these threats or concerns, there is risk for negligent retention, wrongful death, all sorts of claims. There could be statutory employment claims, like I mentioned, workers' comp claims, retaliation, those sorts of things. So there is an obligation upon the branch to act, and that really is the legal position from which I was coming, that as outside counsel, I believed it incumbent upon me to advise the branch of these risks.
Follow up, Ms. So based on the Boley findings that we got that were against talking about workplace harassment, sexual harassment, all these things, would this also fall up under that report in terms of saying that there was an incident that happened and apparently the legislators didn't move fast enough or did nothing, and we are kind of sort of in a similar situation? I think there was a fine that was paid out. Would this doing nothing, would this also fall up under a violation of that Boley report?
Chair Prozanski, Senator Manning, that is a very good question. I have reviewed the Boley settlement conciliation agreement. I don't know that I'm in a position to give you my opinion about that, but I would share that I think that is coming on the heels of the Boley settlement and the other issues that the branch addressed at the beginning of the session. I think it is prudent to keep that in mind when evaluating the situation. While this is different, absolutely, but those same sorts of thoughts and concerns, I think, would be important to keep in mind here. But I don't know that I'm in a position sitting here right at the moment to give an opinion one way or the other whether or not it would run the risk of violating that conciliation agreement. But I certainly think the conciliation agreement is important to keep in mind in this situation.
Mr. Chair, is there a way that we can get some kind of how LC or a legal opinion what the Boley report does if something similar to this, just hypothetically speaking, what that would look like, what our responsibilities would be? Is that practical? Is that doable? Or maybe it's something I need to look at myself?
Senator Manning, clearly you can make that request. There is a kind of unique situation here based on what I remember and I have taken from the Boley settlement agreement as to maybe some limitations on the Legislative Council as to how they advise and interpret for the branch in this specific area. Ms. Baumgart is actually our special attorney who's been brought in to give the independence from the Legislative Council. So that request, more than likely, if we were moving forward on that, would be for me to turn to Ms. Baumgart and say, ask her to provide us with that. So that's, I think, the steps that would need to be taken for that to occur.
I'd really like to hear that.
All right.
Mr. Chair.
All right. First, any